Get ready, start. Inconsistent attitude of the petitioner is evident from the fact that in the present proceedings he is of the view that ejectment proceedings could only be filed by the landlord, but while filing application seeking leave to contest in the ejectment petition filed by the landlord, he took clear-cut stance that since the landlord is not a registered institution, rather it is being run under the Partnership Act, the ejectment petition on its behalf was not maintainable. According to statement of PW4 Real Sun brought on record by the respondents through a miscellaneous application, the monthly rent has been paid by predecessor in interest of respondents. He also affirmed the factum of execution of agreement between predecessor in interest of respondents. Now, coming to the case law cited by the learned counsel for the petitioner, I am of the view that the same is distinguishable from the facts and circumstances of the present case, inasmuch as in the referred case the lease agreement between the landlord and tenant was in written form, whereas in the case in hand the original tenancy between the predecessor in interest of respondents and the landlord was oral in nature. Further, the apex court of the country held that tenant cannot resist ejectment petition while challenging the status of the landlord. The discussion made in the foregoing paragraphs leaves no ambiguity that, as a matter of fact, predecessor in interest of respondents was tenant under the landlord and the petitioner entered the rented premises as subtenant. As a necessary corollary to the discussion made in the foregoing paragraphs, I see no merit in this petition. Resultantly, the same is dismissed with no order as to cost stop.